Hi everyone, Dave Sugden of Evidence at Trial. Let's talk about hearsay. Specifically, let's talk about the prior inconsistent statement exception to the hearsay rule. This is an important rule to understand, and in addition, how this exception is applied in the California Evidence Code is different from the federal rules, and the difference is significant. So let's get into it. Let's suppose we have a hypothetical doctor whose job was to give recommendations about how to handle a global pandemic. And let's suppose one of the issues in our case was whether this doctor ever made the recommendation to the president that the country should be shut or locked down. The doctor denies this allegation, and it is anticipated that at trial, the doctor will testify that he didn't recommend locking anything down. It's anticipated that he'll say something along these lines.
No, I don't, Neil. And in fact, I think we need to make sure that your listeners understand I didn't shut down anything.
In addition, we have evidence that he's given interviews to newspapers where he, speaking in the third person, tells a reporter, when people say Fauci shut down the economy, it wasn't Fauci. The CDC was the organization that made those recommendations. But show me a school that I shut down and show me a factory that I shut down, never. I never did. Now, that quote is a little odd. It's a little like your buddy telling you to turn left, and once you're lost, your buddy tells you, I didn't get us lost, I just made the recommendation that you turn left. Regardless, as you get ready for trial, you're made aware that this witness made statements that are inconsistent with his anticipated testimony. For example, as to the issue of whether this doctor ever made the recommendation to shut down the government, we have this.
I recommended to the president that we shut the country down.
And in fact, we also have evidence that this doctor previously indicated that he wished the shutdown was done earlier.
If I knew at the time that shutting down would have such a dramatic effect on controlling the spread, obviously, we would have shut down earlier.
So, will these inconsistent statements be admissible at trial? Let's first look at the hearsay rule. And in prior videos, I've provided a simple working way to recognize hearsay. But here, we're dealing with an inconsistent statement from the witness's anticipated testimony. So we have to consider two issues. One, will the inconsistent statement be admissible? And two, will the inconsistent statement be admissible as substantive proof? In other words, can we offer the inconsistent statement to prove the truth of the matter asserted? Can we offer the inconsistent statement as affirmative proof that this doctor did recommend shutting the country down? Let's first take a look at California. Evidence Code Section 1235 provides that evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing and is offered in compliance with Section 770. So we need to now turn to Section 770, which provides that unless the interest of justice otherwise require, extrinsic evidence of a statement made by a witness that is inconsistent with any part of his testimony at the hearing shall be excluded unless A, the witness was so examined while testifying as to give him an opportunity to explain or to deny the statement, or B, the witness has not been excused from giving further testimony in the action. This is really important because it provides the mechanism in which the inconsistent statement can be offered as substantive proof. Think of this as the anti-sandbagging rule. In other words, you could cross-examine the witness, excuse the witness, and then have another witness show up, authenticate the video, and play it and offer it to the jury as substantive proof. But you can't do that. Instead, what you would need to do is, with the doctor on the stand or not excused, lay the foundation, play the video, and simply ask the doctor, that was you on such and such a date, correct? And that's it. The witness can deny it, try to explain it on redirect, but that inconsistent statement is now admissible as substantive proof. Now, what about the federal rules? Federal Rule of Evidence has a different approach. Federal Rule 801, subdivision D1A, deals with inconsistent statements, and technically, it's not treated as an exception to the hearsay rule, but instead as a statement that is considered not hearsay. But the requirements for the statement to be admissible as substantive proof requires that the declarant testifies and is subject to cross-examination about a prior statement, and the statement is inconsistent with the declarant's testimony and was given under penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. So unlike California, the inconsistent statement needs to have been given under penalty of perjury at a trial, hearing, or other proceeding. An interview is not something given under penalty of perjury, and thus the inconsistent statement does not fall under this definition. Does this mean the statement is inadmissible? No, it is admissible, but it would be admissible as impeachment evidence, not substantive evidence. In other words, the evidence would be allowed to attack the credibility of the witness, but it cannot be considered as substantive evidence necessary to meet a party's burden on a particular issue. So there it is, the inconsistent statement exception to the hearsay rule. Folks, I hope this was helpful. If it was, please like, subscribe, hit the notification button. If you want a topic covered, leave a comment. If you want to do a deep dive on these evidentiary issues, check out our online course page at evidenceattrial.com. Thanks for watching.